right, and good evening, everybody. Welcome to our webinar workshop on Georgia estate planning, why it's easier than you think. My name is Joel Beck, and I'm an attorney here in Lawrenceville, Georgia with the Beck Law Firm, LLC. If you're on this webinar tonight, you've probably heard that estate planning is important. You probably think it's a good idea, and you want to take steps to protect yourself, protect your family, and make sure that you document your wishes and that they are followed. But you may have questions about how to do those things. What documents do you need? Importantly, what documents do you not need? And what are some of the common problems, and how can you do your estate planning in a straightforward, easy to understand way? And so that's what we're going to talk about today. A little bit about me. I'm born and raised here in Georgia. I've lived in the Gwinnett area since second grade, so that's been a long time. In my law practice, I help folks plan for and prepare for the what if questions in life. For example, what if we die? What happens to the kids? What if I'm incapacitated? Who makes medical decisions for me? Or who pays the bills and manages my assets and my money when I'm laid up in the hospital or when I'm not mentally able to handle my affairs? So to answer these questions and plan for them, I help individuals and families with their estate planning needs. And these what-if questions I mentioned are the ones that we all have to wrestle with, me included. And I learned a good deal about these matters in law school, but I got to experience things firsthand when I helped take care of my grandmother. Now, I'm the only son of two only children. My mom died while I was in college, and after that, my mom's mother, my grandmother, asked me to help her as needed. And so I was named her agent in her power of attorney, and later had to take care of her financial affairs and then deal with end-of-life medical decisions as she grew older, became incapacitated and ill, and then died. And then I served as the executor of her estate. In dealing with those situations, I understood firsthand how important some proper planning can be from a time when I was a young adult, just starting my own family. Now I'm married and have children myself, and I understand the need to plan and make sure that my affairs are in order so that should something happen to me, that my family will know my wishes and things will be squared away. So I understand these what-if questions that life presents us. And I want us to talk together through some of these issues on a fairly basic level today. I'm going to provide you with an overview of the common planning tools that we use in Georgia today. And I'll talk about some things to consider when doing your planning and say a few special words about planning for special situations. Now, during today's live presentation, you have the ability to send in questions through the chat function as we go along. So I invite you to do that. Actually, it's the questions panel that is on your GoToWebinar control panel. You can type in a question and send it on to me. At the end of my presentation, I've reserved some time for us to address questions. I don't know that I'll be able to answer them all, but hopefully we'll be able to address some. Now, but first, we can't have a program like this without a disclaimer. So here it is. This program tonight is provided for general educational and informational purposes only. It's not intended to be legal advice for you or anyone else. So if you want legal advice specific to your situation, you need to hire a lawyer. It's just that simple. And with that out of the way, let's start diving in. And let's begin by debunking a common myth. And that is that planning is just for the wealthy. The truth is, estate planning is simply a way to make medical decisions, to make decisions as to who will care for you and help with medical decisions and financial management and how you want to dispose of your property when you die. And so based on those items, then the definition of estate planning really isn't something that's only reserved for the ultra wealthy. It's something that we all need. Now, when we break down our planning further, there are two categories of time that we have to address. One is the time in which we're alive. Second is the time after we die. And we have to understand that these two time periods are different. And the basic documents that are used for planning purposes are only valid for one of those two time periods, never for both. And I'll explain more as we discuss each one. Now, before we talk about planning tools, let me talk briefly about the current estate tax situation. Now, I don't want to get bogged down or bore you on tax talk, so let me cut to the chase. The estate tax laws were significantly modified in 2013, and what that leaves us with is good news on the tax front. In 2017, this year, the estate tax exemption, what we call the unified credit, is set at $5.49 million. The maximum estate tax rate for assets that are over that level is 40%. Now, this exemption amount, the $5.49 million, is indexed to inflation, and it gradually increases each year as inflation creeps up. And so what this means to you as an individual is that you need to have assets in your taxable estate over $5.49 million before any estate tax would be due. And for assets over that amount, it would be taxed at a maximum rate of 40%. Now, in 2013, with these changes, federal law provided for some portability. So if one spouse dies and the assets in that spouse's estate did not use up all of that unified credit, the remainder can be ported, or it can be moved and applied to the surviving spouse's unified credit when he or she dies to protect even more assets from the estate tax, provided this is handled in a proper way. Now, understand that these tax law changes are defined as permanent, but that doesn't mean they really are. Permanent here only means that they're permanent until another law is passed that changes it. But that's as permanent as we get under the law. In other years, prior to these 2013 changes, the estate tax laws would change over a certain period of time, or they would sunset, and now they're defined as permanent. So until Congress and the President enact different legislation, if ever, then this is permanent. And so that helps us a lot in our planning. Because of these changes, the vast majority of folks don't have to worry about any federal estate tax issues, quite simply because their net worth for their taxable estate is less than $5.49 million. Now, that's the federal side. Let's talk about the state side. Here in Georgia, if you're listening to me today, there's not an estate tax if you die this year. There's currently not an estate tax in Georgia for somebody who dies on or after January 1, 2005. Now, keep in mind, the laws can change. And of course, be mindful that if you move to another state, the estate tax laws in that state may be significantly different. So the good news is, for most people, you don't have to worry about an estate tax situation. And so we're going to focus our time today on planning for folks who don't have to worry about estate tax, which is most people. So let's start digging into that and talking about the planning tools that we want to use. There's a lot of things out there: wills, trust, revocable trust, family trust, living trust, irrevocable trust. You've probably heard a lot of different language used, and maybe somebody has said, you need this, you need that. We're going to dig in and kind of talk about what most people in Georgia in 2017 need. And so first, let's talk about wills, which is what folks generally think of first when considering estate planning issues. So what is a will? It's simply a written instrument that's completed properly under the law that sets forth your plan for distribution of your assets when you die. And understand that a will has absolutely no power while you're alive. Remember, we talked about those two time periods, while you're alive and after you're dead. The will has no power while you're alive. It becomes effective, or it can be used, implemented only after you decease. So let's talk about some key points or key considerations for wills. In your will, you're going to identify somebody to be your executor. And that's simply a person who will manage your estate and distribute your assets in accordance with your will, subject to oversight from the probate court. Now, your executor should be somebody you can trust, who's responsible and can handle going through your will, gathering your assets, paying your bills, and then distributing your assets according to the will and filing the appropriate papers with the court, or working with an attorney that he or she hires to handle the probate, to handle these things on behalf of the estate. It's not necessary that your executor be here where you are. Executors can be residents of other states. Oftentimes, when that's the case, the executor will engage a local probate attorney to help settle the estate. I think that it's important to name a backup executor who you would want to serve as your executor in case your first choice is not able to serve or refuses to do so. And if you'd like, you can list multiple backups for this role as well. Your will include an identification of who is to inherit assets from you. And if you want someone to inherit a specific piece or item, those can be listed. For example, I give my golf clubs to my nephew Jerry, or I give my watch collection to my daughter Lori. And the will is very important as well when it comes to looking after minor-aged children or children that have just reached the age of maturity, which in Georgia, majority, which in Georgia is 18 years of age. And so along these lines, for our minor-aged children, we're going to name a guardian or guardians in the will who, with court approval, will become the legal guardians of your child in case you die and no other parent is alive. Now, understand that in situations where parents are divorced and the non-custodial parent survives or outlives the custodial parent, that non-custodial parent may very well gain custody of the child regardless of the custodial parent's wishes. Issues with that are really beyond the scope of tonight's program, but I just did want to bring that to your attention. In terms of choosing guardians, you have to consider your parenting and discipline style, your faith and values, and obviously your child's relationships with these potential guardians. Take into consideration that person's ability and willingness to serve in this important role. And remember that their financial situation is not what they'll rely on to support your children. You should be planning for that event with your own assets, including life insurance. You'll also need to identify a backup or several backups as guardians in case your primary choice is not able or willing to serve when called upon, if something happens to them. And if you get really stuck, think about this. Somebody that you and your children know will almost certainly be a better choice than DFACS making the decision without your input. As we continue to think about planning for our young children or very young adult children, you're probably going to need to name a trustee. And the trustee is the person who manages the assets that you leave behind for the care and support of your children. If you have a trustee that's a separate person from the guardian, what you do is you spread the work around. And in my view, you create accountability and checks and balances. And that can be a very good thing when it comes to making sure that your children are appropriately cared for. Now, in preparing your estate plan for minor-aged children or those just above that age, consider whether you want to give them an inheritance at 18 or even at 21 or 25. It may be wiser to trickle out an inheritance over time so that your child or children can complete their education. They can get a job and work and understand the value of a dollar. They can become more mature and responsible so that they can handle receiving a sum of money, whether that's $10,000, $50,000, $100,000 or more. Now, I mentioned earlier that my mom died when I was in college. I was young, 21 years old. The law said that I was an adult. But I'll tell you today, I was not mature enough to handle getting an inheritance of any real size back at that time. Fortunately, I still had my dad, and he took care of everything related to my mom's estate and assets. Most all were joint with his. They had a pretty straightforward, normal situation. But had that situation been different, the outcome might not have been good. And so to this end, when we think about leaving money to children or to young adults when you pass away, or when the last of you and your spouse passes away, you may want to consider distributing assets in portions. For example, you can give a third at age 25, one half of the remainder at age 30, and the rest at age 35. Now that's just an example, and there's a myriad of ways to do this. Other ideas might be to leave some at 21, some at 25, and the remainder sometime later. The key is to devise a plan that you're comfortable with and that you think works well for your family and for your wishes. And this can help ensure that an inheritance for your children becomes a blessing and not a curse, and also that it's not squandered. Now, I want to talk about a few points to consider so that maybe we can avoid some problems as we do our estate planning and put together a will. First, be careful choosing your fiduciaries. Your fiduciaries are the guardian, the trustee, the executor. You may not want to have one person serve in all of these roles. By having different people in the roles, as I said before, you share the work, it can make it easier, and it can promote greater accountability. And with respect to minor age children, you have two people looking out for them, the guardian and the trustee, instead of just one person, and that can really be beneficial for your child. Creates accountability, checks and balances. That's a really good thing in my view. Be careful as well about asking people to serve in a role jointly. What I mean there is asking two people to serve as guardian or two people to serve as executor or trustee. You have to consider what happens if one of them can't serve. Can the other one serve individually? But what happens if they don't get along and they can't agree on a decision? That can cause a real mess. It can cause some fractured relationships and can result in things costing more money to fix than it ought to. Remember this truth: if two people don't get along while you're alive, don't expect them to get along after you die. And in fact, if they're fighting for money or control, it may just get worse. And along these lines, there's an old saying of estate planning attorneys that you would do well to remember as well, and that is this: everyone gets along until daddy dies. Don't just trust that somebody will do the right thing. Your family members are angels, I know, until they're not. And some people may try to take steps to not follow your wishes. Now, one more tip I want to share for potentially avoiding problems is this: be careful about leaving assets to people to own jointly. Don't force family members who now don't get along into partnership with one another. Recognize that while everybody may love the idea of a cabin in the mountains or a condo at the beach, not everybody can afford the upkeep and maintenance of that, the taxes, all of the expenses. And that might make them not able to fully participate in tending to the needs of the property, and again can lead to some relationship issues. Speaking of joint ownership, it's not necessarily a good idea to put your assets in the name of you and a child or another person jointly during your life, and then expect that those assets will be shared with others following your death. If you put those assets in a true joint tenants with right of survivorship account, then once you die, those assets belong 100% to the other person, and they're not part of your probate estate. Let me talk briefly about a couple of special situations that come up in estate planning. First, if you have a family member or a loved one that has special needs or developmental disabilities who receives government benefits, you really need to consult an attorney who does a lot of work in this area to help you craft your estate plan, because you may very well need to leave assets for that person in a special needs trust, a supplemental special needs trust, to supplement other support that they have. Don't try to handle that your own. Second, blended families. As I said before, everybody gets along until daddy or mama dies. Plan with that in mind. Blended families, very common today. They say that the statistics for the divorce rate in our country is somewhere around 50%. So it's very common for a person to marry to have children, and then that marriage may end in either divorce or the death of a spouse, and then they may marry another person, creating a blended family. Think of the Brady Bunch. In these situations, though, you need to take care for how you're going to leave your assets and who's going to be in charge and what that plan is going to be. Relationships after the death of daddy or mama may change drastically, and so your plan needs to recognize and kind of plan for that possibility. You may want to leave something for the kids at your death and not wait for their stepmom or stepdad to die before receiving any of their inheritance. That may help lead to better relations among the blended family members following your death. And finally, a word for business owners. If you own a business, you really need to make sure that you tackle succession issues. Now, that may include selling the business to others, either third parties or certain family members, or leaving the ownership of the business via your will. Be careful, though, about the relationships of those family members who work in the business and those who don't. You have to understand that leaving the business in joint ownership of those who work in the business and those who do not is asking for a heap of trouble, as well as likely creating a situation where the family members working in the business are pitted against those that might become parasites. Now, once you get your will done, you've signed it, we've gone through the ceremony to execute the will under law, and so it becomes valid and can be used when you die. Understand that you're still not done. You need to review it from time to time. You have to make sure that it still reflects your wishes. And so you need to review your choices for executors, for trustees, guardians, to make sure that these are the folks that are still capable of serving and you're still comfortable with that selection. If a change needs to be made, maybe you want to change a fiduciary or you want to change a part of your plan of distribution of assets, you need to know that you can't simply mark through a provision of your will. You can't just take a pen and cross something out and initial it or write something else in. It's not going to have a positive effect, and you might actually invalidate your will so that it cannot be probated. Remember as well that certain life events may make your will or parts of it invalid. Your marriage or divorce or the birth or adoption of a child can have some consequences to your will unless your will specifically provides for those possibilities. So far, we've talked about probate assets, and those are the assets that your will actually distributes upon your death. But it is very important to remember non-probate assets. And what you need to know is that not every asset that you have is going to get disposed of via your will. Property that you hold jointly with others with a right of survivorship gets distributed automatically to the surviving holder. And certain bank and investment accounts, retirement accounts, where you designate a beneficiary with the custodian of that asset, don't go through your will. Instead, they're distributed in accordance with your beneficiary designation. And this is true for all retirement investment accounts, your IRA, your 401k or 403b accounts, for example, as well as for life insurance policies. And so this means you have to make sure that you have designated beneficiaries for these non-probate assets so that they are going to pass to others when you die in accordance with your wishes. And if you have minor-aged or young adult children and you want to have assets held in trust for them, it's critical to work with your lawyer and with your financial advisors on the proper way to designate beneficiaries to ensure that those assets are going to come into the trust that's part of your will. Now, we've covered wills. Remember that your will only has power and can be effective after your death. We're going to now talk about two planning tools that are used during your lifetime. And the first one that I want to talk about is the Georgia Advance Directive for Healthcare. And this is a document that combines the provisions of a living will and a durable power of attorney for healthcare into one document. And so the ADH allows a person to designate somebody to be their healthcare agent and provides that agent with your treatment preferences, such as whether to be kept alive by artificial means, whether to get nutrition or fluid by tubes, or whether to be allowed to die a natural death without heroic measures. So this advance directive gives the healthcare agent the powers to admit or discharge the patient from treatment, to request or consent to any type of care, and to contract for the provision of medical services and care, obligating the patient to be responsible for payment of those services. Importantly, the healthcare agent only has authority to act if the patient is not able to make decisions for himself, or if the patient chooses to have the agent get involved and make decisions on his or her behalf. The ADH also does not apply to mental or emotional illness or to addictive disease. Finally, with respect to the advance directive, it allows for the appointment of a designated guardian over the patient should a court determine that a guardian is necessary. And you can designate your healthcare agent or somebody else to be appointed guardian if necessary. So this gives you some input and control in that type of situation. Now, like a will, the advance directive needs to be executed, needs to be signed with some formality. You're going to have two witnesses present who are going to sign as witnesses. So one of the questions we get is, why do I need one of these? Well, quite simply, if you become incapacitated and cannot make decisions for yourself, this advance directive provides a designated person that you've chosen to make decisions as opposed to perhaps somebody being appointed by a court. And by providing your treatment preferences, you're assuring your agent and your other family members that you've considered these issues and reached a decision as to how you want to be treated and have communicated those wishes through your advance directive. That, I believe, helps relieve some of the stress and pressure from the situation, and certainly can help the agent not have to guess how you want to be treated. Now, we talked about needing to review your will from time to time to make sure that it still reflects your wishes. And you need to do that with your advance directive as well. Certain lifestyle changes, such as a marriage or divorce, could invalidate your advance directive or part of it. So whenever you have a big lifestyle change like that, be sure to review your documents with your estate planning lawyer. Now, the advance directive is really only good if it's known about. And so you need to let your agent know that they've been selected by you to be your healthcare agent, and give them a copy of it, or let them know how to find it and be able to access it. If it's locked up in a safety deposit box and they aren't on the signature card, they're not going to be able to get it in a timely manner. So be sure that they know both where it is and they have access to it, or just give them a copy. You may provide a copy of it as well to some of your doctors or medical staff. Some local hospitals may keep it for you in your patient files there if you are going to be admitted. So that's the advanced directive. Let's talk about the third and final basic planning tool that we generally use in Georgia, and that's the durable power of attorney. Now, the durable power of attorney grants another person the ability to act in your place and tend to your affairs by your express permission. The POA typically grants the agent the ability to manage your financial affairs, your bank and brokerage accounts, to pay bills, buy or sell real and personal property, pay taxes, etc. These powers are generally broadly drafted and often give the agent the authority to do anything on behalf of the principal, you, that you could do for yourself. And so that makes this a very dangerous document, and you should only grant power of attorney authority to someone you really trust. Now, somebody who's going to act as your agent, they have an obligation under the law to act in your best interest. They are fiduciaries to you and owe treating you in a fiduciary duty or with a fiduciary duty. When we put the POA together and sign it, it can become effective. That power can become effective immediately for your agent, or it can be made to become effective only at such times or such time that you're incapacitated. Now, fair warning, it can be tricky to define incapacitation for purposes of a power of attorney, and care needs to be taken if making the power of attorney effective at some time other than immediately. Now, the durable word in the name, durable power of attorney, means that the POA will be effective even if you're incapacitated, and that's really a key feature. Having a non-durable POA is possible, but that's not going to be effective in the event of your incapacitation, and that's a problem. Many studies suggest that for most of us, we outlive our capacity, and so having the durableness of the power of attorney is very important. All right. So these three documents, the will, the advanced directive for healthcare, and the durable power of attorney, form the basic foundation of estate planning tools in Georgia. And for many people, these are the only documents that are needed. Now, there are many other tools that can be helpful and useful depending on your needs and goals, and obviously depending on your specific family and financial situation. Things like revocable living trust can be used to help avoid the probate process and to speed up the process of distributing certain assets when you die. They can be very good tools in keeping more of your estate private because the documents are not filed with the probate court. They can also be a good way to help avoid the need for a conservatorship down the road as well, or to help protect someone's assets from predatory family members or friends who might take advantage of a loved one's good nature and their inability to say no. While these revocable trusts, or living trusts as they may be called, do have some advantages, unlike in many other states, the avoidance of the probate system in Georgia is simply not a compelling reason to put a revocable trust in place, in my humble opinion. Instead, we're going to reserve those tools for some other specific reasons that makes using the tool make sense beyond probate avoidance. We have a fairly good, fast, and economically efficient probate system in Georgia. Now, I am often asked whether a lawyer should be used to help folks with estate planning, even for these basic foundational documents. My answer is always yes. I think that an experienced estate planning lawyer can help folks identify their needs and their goals and objectives, and then figure out the best options available to meet those needs and objectives. The value that an experienced planning attorney brings to the table is really far more than filling out a form. It's knowing the questions to ask, understanding the common errors that can be made, and then helping the client formulate plans that work well, that comply with the law, make sure they're executed properly, and that they're designed to avoid problems that may thwart the client's objectives. And so if you ask me whether I think it makes sense for folks to work with a lawyer for their basic planning needs, my answer is yes, whether that lawyer is me or somebody else who's experienced in this field. Some people are put off at the prospect of paying more than the cost of an online do-it-yourself will kit that, of course, might not be completed properly and may or may not get your wishes carried out. Good planning is going to cost more than that, but litigation, because of poor planning by your heirs, it is much more expensive. Now, I do have a free offer for you if you're on our webinar tonight. We have some free information about basic estate planning that we're happy to send to you. And this information outlines some of the information that we've discussed today, including information about wills and advanced directives. We also have some information to help folks in the process of selecting guardians for their children. I think that the selection of guardians is probably one of the biggest stumbling blocks to getting planning done for those people with younger children. And so we've got some simple steps that help break down this decision-making process, makes it easier. If your children are grown, you might not need that info, but it might be good for others in your family. We're happy to send that to you. So we're happy to get this information out to you in the mail for free, no strings attached. To get it, simply send an email to my legal assistant, Connie. Her email is on the screen there, connie@thebeckfirm.com. What I need you to do is provide your name and a mailing address and just ask her for the free information from the estate planning webinar. She'll know what you're looking for. We're going to get that packaged up and get it out to you in the mail right away. So right now, we've got some time for some questions. And if you've got a question about what we've covered tonight, you can go ahead and type that into the questions panel on the GoToWebinar control there and send those straight on out to me. And I'm going to try to take some time and answer these. We're going to stick, and we're going to make sure that I honor my time commitment. We're going to be done in 57 minutes or less, but we do have some time for some questions. All right, so here's the first one. What happens if I die without a will? That's a good question. We call that intestate succession, and what that is, it is a plan for distribution that's made up by state law. So in Georgia, generally speaking, your assets will pass to your spouse and to your surviving children, who will share everything in equal shares, but the spouse will not get less than a 1/3 share. You don't have a spouse or children, then we look at other descendants and then start looking at parents or grandparents and then branching out from there to figure out who gets your stuff. This is the state's plan for people who don't make their own plan. And it's probably not exactly the plan you want for yourself. And that's why it's better, in my view, for each person to put a plan in place that they've approved of by doing their own will. All right. What happens if the people listed as my executors can't do the job, they die, or are not able to do it? Good question. If you've got a will in place and the people that you've listed as your executor and your backup executor, if they've predeceased you or they're incapacitated or can't serve or refuse to serve, the court will appoint somebody else to be your executor. Your will shall not fail for lack of an executor, and any trust in that will shall not fail for lack of a trustee. The probate court, the judge will appoint somebody who's qualified to step in and kind of take over and work your plan to get the job done. All right. Do I need to give a copy of my will to others? You know, I get that question a fair amount. My answer is no, and here's why. I've never seen anything good come out of somebody sharing their will with other people while they're alive. but I've seen some bad things happen. I've seen some family relationships break down because maybe in one case I'm recalling now, a child was not treated equally like others. That child was told about this, and it led to some challenging times and fractured relationships. For this particular client, there was good reason that this child was not treated the same as some siblings, but it can still cause some problems. But beyond that, recognize that, first off, your will is private. Second, as I mentioned, it has no power during your life. And with that in mind, the will that you have now, or that you may soon have, it may not be the last will. You may change it before you die. You may have a change in who you want to inherit from you, or you may change how you want those assets to be distributed. You may change who you want as your fiduciaries. So the will may not be your last one, and so you may not want to go ahead and share that with others for all of those reasons. Okay. I have POA for my father. I've heard that I can continue to manage his money with that POA. Of course, POA is power of attorney, when he dies. Is that true? No, it's not. It's not true. The power in the power of attorney ends, it extinguishes when the principal dies. Think of it this way. Under a POA, the agent can only do things that the principal can. If the principal is dead, the agent then can't do anything. So no. All right. If you moved from, say, Florida to Georgia, must you have your durable power and healthcare powers revised, or even your will, living will, or trust? Good question. Generally speaking, if your planning documents were validly executed under Florida law, in this case, if they're validly executed, they comply with the law, then they're going to be honored in Georgia. Just because you cross state lines doesn't render, your planning documents null and void. The issue may be, though, that under Georgia law, maybe there might be some other things you could do or other ways to handle things. For example, Florida generally has a more complex probate system than Georgia does. And so in Florida, more people use a living trust or revocable trust, family trust, something like that, so that they avoid probate, whereas I mentioned earlier in Georgia, we generally don't worry about that for most people. Some situations we do, but probate avoidance is not as big in Georgia as it is in Florida and California and some other states. So do you need to redo your documents just because you've moved? No. What you may want to do, though, is consult with an estate planning lawyer in the state that you've moved to. Get those things reviewed, have a consultation, and see if it would make sense to redo it. So that would be my answer to that. All right. Any other questions? Last call for questions here. All right, let's see. One more came in real quick here. A durable power under Florida law is no longer springing and are active immediately. Does that remain the same in Georgia? Well, I can't comment on Florida law. What I'll tell you is that in Georgia, you can have a power of attorney that is effective immediately or effective at some date or event in the future. And some people will commonly call that a springing power of attorney. The power springs into being at some point in the future. Oftentimes, for a lot of our clients here, we will go ahead and make the durable power of attorney effective immediately so that we avoid issues relating to having to prove a future incapacity or issues with respect to the time that may take. But certainly we can craft durable powers of attorney in Georgia that are springing. So I hope that answers your question. If not, you feel free to give me a call this week or next. We can talk about that. So those were some good questions, y'all. So thanks. And I don't see any others coming in right now. And so what I want to do now is just kind of go ahead and wrap up. And let me tell you, thanks for attending our session tonight. I hope that you found it worthwhile and informative, and that now you find that estate planning is not as complicated as you perhaps feared that it might be. You can find more information about estate planning and about our law firm, the Beck Law Firm LLC, online. Our website is there up on the screen. Don't forget about our free offer. We're happy to send you some information about estate planning in Georgia. I just need you to email Connie@thebeckfirm.com, ask her for the estate planning webinar info, and give us your name and a mailing address. This is going to come old-fashioned in the mail. It's going to be delivered by a letter carrier to your mailbox. So give us that info. No strings attached. We'll get those items out to you promptly. Again, thanks for attending. If I can be of further help to you, I invite you to give a call to me and be happy to talk with you further. Thanks again for attending, and good night.